Hello, everybody. Welcome to this seminar. We're just going to wait a minute just to make sure everyone else can log on who's joining us today. So I'll start in about a minute's time. At the meantime, I'll just go through briefly the meeting instructions. You will all have been placed on mute so that we can everyone can hear the speakers. Please post the questions that you have in the Q&A window. There is a chat function enabled, but that's for other comments and queries or feedback. So don't put your questions in the Q&A window. We will be circulating the resources, the slides, after the webinar, so don't worry about that. And the other thing you need to know is that the webinar is being recorded, which means that if you do make a contribution, then you'll be recorded too. So you need to be aware of that. We will be sharing the recording on our marketing channels, website, social media, and so on in the usual way. If you have any technical questions as we go along, refer to the instructions in the chat window, and we will try and deal with them as and when they crop up. Thank you. So we are ready to begin. This is part 2 of our retained EU law webinar on and yesterday we looked at the overarching framework of how retained EU law works under the European Union Withdrawal Act, and today we're going to look at some worked examples of how it works in particular areas of law. And also we have joining us today Dr. Ruth Fox, who is the director of Hansard Society, and we're very lucky to have Dr. Fox with us to take us through how statutory instruments are made, and also to show us how the Hansard Society statutory instrument tracker works. So we're going to start off with Abigail Holt from Chambers, who's going to look at the context of health and safety law and look at retained EU law in that context. And I'm going to show you something on immigration and social security and just touch on some employment issues arising. And then Dr. Fox is going to take us through the statutory instrument tracker. And then Ollie Percy, who's also in Chambers, is going to look at the retained EU law in the context of Equality Act issues. So we have a packed hour. It's going to go by very quickly, and so we'll crack straight on and go over to Abigail to take us through her area. Thank you.
Thank you, Adrian. I'm just going to share my screen. Okay, I think that should be up and running now. Welcome everybody to my study again in sunny Manchester, as it happens. So just to recap, yesterday I was talking, amongst other things, about the filtering of domestic law, which will be done pursuant to the EU retained law, and how the executive is starting the process of diverging from EU in terms of doing the heavy lifting of this process. A lot of it will be done through statutory instruments, especially pursuant to Section 8, which will be used to weed out deficiencies. Ollie yesterday touched on the fact that the enabling legislation is not limited just to the Withdrawal Act as amended, but includes the European Communities Act 1972. And Ruth later will talk about the fact that various committees in the House of Commons and the House of Lords will have the role of looking at the statutory instruments and other provisions which will do the lifting. So in preparation of this webinar, I looked at Lexis this week and saw that since August of 2018, there have been 1,091 Brexit-related statutory instruments laid in Parliament. Because of my interest in health and safety, I did a search in relation to health and safety statutory instruments, and 64 were thrown up. And this is a list of some of the main areas that were dealt with in that list. Now, perhaps one of the statutory instruments that was thrown up as being laid before Parliament was the Health and Safety Amendment EU Regulations 2018, which says that it ensures that EU-derived health and safety protections will continue to be available in domestic law after the UK has left the EU. And these regulations don't take any policy changes beyond the intent of ensuring continued operability of the relevant legislation. So on the face of it, that looks like good news for consumers and for employees, people who typically rely on health and safety regulations. However, there is a bit of a backstory to my concerns, and that's related to the whole issue of what is known in the press and elsewhere commonly as elfin safety. Many of you will be aware that the Health and Safety at Work Act 1974 allowed for regulations to come into force, and very important six-pack regulations, as they're called, came into force at the beginning of January 1993. They largely replaced the Factories Act 1961. As it happens, subsequently, many of them have been updated, but these six lots of regulations are set out here. And the Management of Health and Safety at Work regulations are perhaps the most important in terms of they implement the Framework Directive and also Temporary Workers Directive, and give an overarching guidance to the other regulations. It is also important to note that one of the big cultural changes that those health and safety regulations brought in 1993 were the whole concept of risk assessments, which is currently part of our law. But it is something which is important, in my view, to continue, but query whether the insurance industry have quite the same view of the whole issue of risk assessments. When I looked at the Health and Safety at Work Act 1974 yesterday to check for updates, this is what I was met with. Somewhat discombobulating, but effectively the government website, the legislation website, is saying that in effect that I can't be confident that any amendments have been made. And so looking at the legislation now, it's not entirely clear what the effect is of any of the recent changes through statutory instruments. Another reason for having concern as to what might happen with regard to health and safety legislation under EU retained law really goes back to an amendment that was made through the Enterprise and Regulatory Reform Act 2013. So even though post-transition period, there's no immediate notification, it's not immediately obvious that significant changes to health and safety law are in the pipeline, but nonetheless, in the recent past, there has been a significant change. That was through the Section 69 of the Enterprise and Regulatory Reform Act 2013. And that was passed specifically with the express intention of reducing the burden of health and safety legislation on businesses. It was a small but significant change insofar as the change to the domestic legislation removed strict liability and effectively put the burden on claimants to prove that there had been a breach of statutory duty or negligence if they were relying on regulations. So that effectively put greater pressure on claimants. They had to show that if they were injured, that their employee had failed to take reasonable care to provide, for example, safe plant and equipment. So, as I say, even though there's no immediate concern so far as the regulations are concerned, it does beg the question of what might happen, because once we are no longer tethered to EU law by the directives which underpinned those six-pack regulations and other regulations, seems to me that the government will be able to amend those domestic regulations, and the status of the directive and the previous EU law will only be indirectly applicable, maybe arguable, but certainly on the face of it, it would appear that protections potentially will be removed. Another example that illustrates really the confusion and difficulty in this area is in relation to the personal protective equipment regulations. They were one of the six-pack regulations, and of course we've all heard a lot about the personal protective equipment regulations as a result of the pandemic. And you will recall that in March of this year, there was something of a panic because there were concerns that there would be sufficient PPE available and query at sufficient quality. In that regard, if you look at one of the slew of publications which the government have produced surrounding PPE, in January of this year, the Office for Product Safety and Standards published this document. I won't read it to you. It has a very long and exciting title, but basically it is to consider the situation regarding PPE, including COVID-related PPE, at the point of EU withdrawal. And what's interesting about the documentation is that it's extremely difficult to read. It's written in such a way that it's fairly impenetrable, but buried in the morass of detail is the fact that in March of last year, the UK government followed the European Commission recommendation, which was essentially that the temporary measures could be taken, effectively allowing governments to take further steps to try and source PPE. In a sense, it was an emergency measure to allow, in this case, the UK government to source PPE by means that they wouldn't normally be able to. But what was interesting is that looking at the document, that recommendation seems to have been followed through the whole of last year, and come withdrawal, 11 o'clock on New Year's Eve just gone, in effect, what the government have done, they've taken the opportunity for the temporary arrangements to be continued. So that means that essentially, so far as COVID PPE is concerned, we have a lower standard now than previously. Now, to be fair, it is arguable what those regulations mean, and essentially the tests that the Health and Safety Executive have to carry out are slightly less onerous than previously. The requirements, so far as labelling is concerned, are slightly less onerous than they used to be. But it's not immediately obvious whether the previous standards will be reimposed pursuant to the regulations once those once the recommendation provision runs out, which at the moment is said to be at the beginning of March. So that I've just described a couple of potential problems and areas to look out for with regard to health and safety. But I just want to summarize really and end with emphasizing some of the themes that come out of this whole issue. First of all, in terms of cost of civil cases, the extra legal research is very burdensome, and there are going to be cost consequences against the background of the cost provisions in civil cases, which are extremely complex. And certainly in terms of personal injury litigation, the costs are very limited for cases worth less than £25,000. Secondly, judges are required to assist litigants in person. It begs the question how litigants in person are going to be able to find their way round the slew of statutory instruments which have been coming out of the government sources post the withdrawal period. It's inconceivable that the judiciary will have the time and resources to help people. It also made me think about the fact that essentially we are now turning into legal techies. In order to find your way around this legislation, you have to be increasingly good at searching. And which then intellectually, this means that we're becoming increasingly reliant on data management systems and electronic searching techniques, which slowly gives those platforms a form of power. So the whole culture that we find ourselves in does have implications beyond the black and white regulations themselves. Thank you. Back over to you, Adrian.
Thank you very much. I'm going to share my screen now, hopefully. And oops, no, I'm not. Let me just, sorry. All right. Hopefully you can see that on the screen, and I'm going to go through what we're going to worked examples in the field of immigration and social security. So we have questions, as I said yesterday, to solve as practitioners, and so my ambition is to show you how we would work one out for our benefit. And so the first question might be, can I rely on the old EU law principle that a child in education of an EU former worker can have a right to reside in the UK, and his or her primary carer, even if they're a third country national, can have a right to reside? Would that principle still apply if they came to the UK in 2021? For the first time? And so it's an interesting question, because up until the end of last year, they could rely on that principle. And that principle derives from cases, Baumbast and Teixeira, both of which were cases involving Garden Court Council. I was actually in Teixeira, and the question arises in the context of a regulation. And as we discovered yesterday, regulations can form part of retained, or do form part of retained EU law under Section 3 of the European Union Withdrawal Act 2018. So on the face of it, there's some case law which predates the end of the transition period. And then there is a regulation, which is now Regulation 492 of 2011, which regulates the position of workers, upon which those cases were based. So without more, that workers' regulation, which gives right to this right of residence, forms part of retained EU law under Section 3 of the European Union Withdrawal Act. And of course, you'll remember that EU regulations were directly applicable without being transposed into domestic law. So we're looking at the regulation as it existed on 11 p.m. on the 31st of December, just gone. In addition to the regulation existing, of course, the case law itself forms part of retained EU case law, and the rights recognised as being derived from the workers' regulation, the right of residence for the child of a former worker and the right of residence for the primary carer of such a child, would be rights arising or deployable for under Section 4 of the European Union Withdrawal Act. So on the face of it, things are looking good. We then have to work our way through the statutory scheme and figure out whether any of the exceptions onto retained rights found in Section 5 and Schedule 1 apply. And skipping through that, the answer to that is no. And so without more, we've got a situation where there's now immigration control for new people coming to the UK from the EU in 2021. And there's also a bit of retained EU law potentially. And there's a conflict between the two, because the workers' regulation existed before the end of the transition period. The case law in Baumbast and Teixeira existed before the end of the transition period. And of course, there is the fact that now EU citizens coming to the UK are subject to immigration control under Sections 1 and 3 of the Immigration Act 1971. How would you resolve that conflict? Well, without anything extra, you would apply the principle of supremacy of EU law, which we discussed yesterday, as it's provided for in Section 5 of the European Union Withdrawal Act, and you would give effect to the retained EU law provision. That would be the starting off position. So it looks all right at the moment. We're applying the principle of supremacy. We've identified our piece of EU law, it's retained. We've identified our retained EU case law that's retained. So we look like we're doing well in those circumstances. Could the Supreme Court or the Court of Appeal depart from that EU case law, that retained EU case law? Yes, in certain circumstances, although obviously a case to reach that level would take a while. And then we discussed the circumstances within which if the Supreme Court can depart from retained EU case law and retained EU law on the principles which provide already obtained for it to depart from its own case law. So there is potentially a door out there where the rule could go backwards. So we're thinking we're sitting pretty well at the moment. We've got a bit of retained EU law we can rely on. But what about the regulations made to deal with deficiencies arising under EU law that Abby mentioned yesterday under Section 8 of the European Union Withdrawal Act? And there is one that relates to immigration. There are regulations made, the Immigration, Asylum and Nationality EU exit regulations. Well, we have to have a look at them. There's a lot of them, but they don't mention the workers' regulation. So we're lucky. Whatever deficiencies are dealt with or alleged deficiencies in retained EU law in the Immigration, Asylum and Nationality EU exit regulations, they don't affect us. So we move on to the next stage and we're looking pretty good. But unfortunately, there's another piece of legislation which governs the area. And this is the moment really to think, just to reflect that it's not just the European Union Withdrawal Act that we're concerned with, but individually with other acts of Parliament, whereby legislation has been enacted to deal with the position of the UK leaving the European Union. So in addition to the European Union Withdrawal Act of 2018 and the Withdrawal Agreement Act of 2020, we've got the Immigration and Social Security Coordination EU Withdrawal Act of 2020. And this is the act, which is quite short, but it's the one that provides for the termination of provisions relating to the free movement of persons. And the schedule which is attached to it makes provision, among other things, to end other EU-derived rights and repeal other retained EU law relating to immigration. So we have to go and see, firstly, when is it in force? Well, it's on force from exit day from 11 p.m. on the 31st of December. And it deals specifically with the workers' regulation upon which we're trying to rely. It omits free movement for workers in Article 1. That's simply revoked effectively. And in respect of other provisions, Articles 2 to 10 of the regulations, they remain in force, and we have to look at this legislative technique. They cease to apply so far as they're inconsistent with any provision made by or under the Immigration Acts or otherwise capable of affecting the interpretation, application, or operation of any such provision. So that's a problem for us, because in order to derive a right to reside for the child of a former worker or the primary carer of a child of a former worker, we need to rely on Article 10 of the workers' regulation. But that seems to be plainly inconsistent with the fact that under existing legislation, the Immigration Acts and Section 1 and 3 of the 71 Immigration Act in particular, persons subject to immigration control require leave to enter. And in the result, effectively, this reverses the principle of supremacy. And in this circumstance, where there's an inconsistency, it's UK law which trumps the retained EU law in the form of the workers' regulation. And so Article 10 of the workers' regulation, which we might otherwise rely on, is not available to us. So we know that the retained regulation, the retained direct EU legislation, can't be relied upon. But what about the actual rights to reside themselves, as they're recognised in the cases of Bambast and Teixeira? Well, Schedule 1 of the Immigration and Social Security Coordination EU Withdrawal Act also provides a mechanism for reversing the relationship between the retained direct applicable EU legislation and the existing statute book. It provides that any other EU-derived rights cease to be recognised and available in domestic law, so far as they're inconsistent with or otherwise capable of affecting the interpretation, application, or operation of the Immigration Acts, or otherwise capable of affecting the exercise of functions in connection with immigration. Very, very, very broad way of dealing with it, capable of affecting functions in connection with immigration, functions being undefined. And so in the result, the rights derived from the case law itself are also inconsistent with the fact that new EU arrivals are persons subject to immigration control. And so we lose the principles in the case of bombast and teshera as well, notwithstanding that otherwise they would be retained EU case law. Along the way, we're checking to see what else we need to be looking at. And we find that not only are there regulation making powers under Section 8 of the European Union Withdrawal Act of 2018, but further regulations may be made under Section 5 of the Immigration and Social Security Coordination EU Withdrawal Act, insofar as they relate to immigration. And you can see there that the Secretary of State may make such provision as she considers appropriate in consequence or in connection with, and then, of course, the thing in question, which is the provision to end free movement. And the power to make regulations may be exercised by modifying retained direct EU legislation, as I've underlined at the bottom. So then we just have to check to see if we've got the right answer so far, or anything else changes our view. Have any regulations been made under Section 5 of the Act? Yes, unfortunately they have. The Immigration and Social Security Coordination EU Withdrawal Act 2020, Consequential, Saving Transitional and Transitory Provisions EU Exit Regulations 2020. Do they in fact deal with retained direct EU legislation? Just because there is a power to deal with that legislation under these regulations, do they actually deal with direct EU legislation? And on this occasion, they don't. These particular regulations don't, but it's important that we checked, because we checked the regulation making power, we had a look at the regulations made underneath it, and we can discount them. We also note that those EU withdrawal, immigration and social security EU exit regulations overlap with the regulations made under Section 8 of the European Union Withdrawal Act, the Immigration, Asylum and Nationality EU exit regulations. So we've got two forms of transitional regulations, each made under different statutory powers, covering similar terrain. And if you think that's confusing, it is. And in fact, the latter one, the Immigration and Social Security regulations, make changes which had been anticipated in the earlier one, the Immigration, Asylum and Nationality EU exit regulations. And so you have to make sure you've got the up-to-date version of both of them in order to understand what's been changed. So when we go back to our original question, that if an EU citizen or if the child of a former worker makes that journey to the UK this year, and they're not within the scope, otherwise within the scope of the withdrawal agreement, and they have a primary carer with them, so they're coming for the first time. There's somebody who's been in work, maybe in the UK for the first time, as the worker, as a skilled worker. They have a child, that skilled worker ceases employment. Does the child and the primary carer have a right to reside based on the bombast and teshera principle, based on the workers' regulation? The answer is no, they don't. And so that right has been lost, even though the case law remains retained EU case law, and the regulation 492 of 2011 remains on the statute book as a form of retained direct EU legislation. And of course, it does remain, the workers' regulation does remain. The principle of supremacy is only reversed insofar as it affects immigration matters. But where it's not in conflict, it can still apply. And so Article 7 of the workers' regulation still applies, because that deals with employment rights. And so you'll see there that it creates effectively a kind of a mini way of providing a right to equal treatment, or a prohibition on discrimination on grounds of nationality as regards the conditions of employment, remuneration, dismissal, and so on. And very importantly, in Article 7 too, a right to enjoy the same social and tax advantages as national workers. And the concept of the concept of social advantage is very broad on EU case law. So the workers' regulation remains. It has a subordinate position to immigration law as it arises under statute, but it remains supreme in the field of employment law over national law, which is inconsistent with it. So not supreme in relation to immigration law, but supreme in relation to employment law, which is obviously something to get your head around. That retained EU law may have different places in the hierarchy depending on a substantive setting in which it arises. Two other quick points to note. Firstly, that retained direct EU law may be modified by regulation, and that retained EU rights may be disapplied by regulations. And so if you look at the Immigration, Asylum and Nationality EU exit regulations, for example. Those are regulations made under Section 8 of the EU Withdrawal Act of 2018. Not only do they make changes to UK statutes and statutory instruments, but they also revoke certain provisions of retained direct EU legislation that relates to immigration, and they provide that retained EU rights cease to be recognised, available, and so on in domestic law, so far as they're inconsistent with the provision made in those regulations themselves. So a similar sort of technique. And so you have to look at what's been revoked and what's been amended on the statute book there. And then you have to see whether the EU rights that are retained are inconsistent with that thrust. And then just very quickly at the end, on social security law, this is a fiddly area, as everyone knows. It's it's much more complex than immigration law. On the coordination of social security regulation, which regulated contributory benefits, contributory social security, healthcare and pensions, while the UK was in the EU and during the transition period, ordinarily, that would be a directly applicable piece of EU legislation that would form part of retained direct EU law. Is it now so retained? Well, the answer to that is no. Why is that the case? Well, if you look at Section 6 of the Immigration and Social Security Coordination EU Withdrawal Act, so another piece of primary legislation, not the EU Withdrawal Act of 2018, there's a power to modify retained direct EU legislation that relates to social security, and that power has been exercised under the Social Security Coordination Revocation of Retained Direct EU legislation. So you have to keep your fingers on many tabs when you're trying to follow this through. So the coordination of social security regulation has been repealed, but remember that those people who are here or within the scope of that regulation prior to the end of 2020 will be protected by the citizens' rights provisions of the withdrawal agreement for those who fall within its scope, and further effect is given to that by Section 13 of the European Union Withdrawal Agreement of 2020, the Withdrawal Agreement Act of 2020. And remember too that people coming for the first time for employment and self-employment in 2021 come within the scope of the Protocol on Social Security Coordination, which is annexed to the EU Trade and Cooperation Agreement that was just signed in December, and for which further provision on social security is made in Section 26 of the European Union Future Relationship Act of 2020. And so you can see there's a lot of law to trace through, not just the overarching retained EU law scheme in the European Union Withdrawal Act of 2018, but also a specific primary act to deal with immigration and social security, and also the European Union Trade and Cooperation Agreement and the European Union Future Relationship Act. And underneath all of these are statutory instruments. So it's very important to keep up not just with the primary European Union Withdrawal Act, but to follow through the legislation in your area, and to understand that some retained EU law may be supreme for some purposes, for example, in employment law, but not supreme and may have to yield to domestic statutory provision as it does, as the workers' regulation does in the field of immigration. Thank you very much. I'm now going to hand over to Dr. Fox, who's going to take us through the statutory instruments and the tracker on the Hansard Society. Thank you.
Okay, thanks, Adrian. So just to introduce the context, the Hansard Society has been scrutinising the passage of statutory instruments through Parliament for nearly a decade now, and has been monitoring them individually and tracking them since the start of the 2017 parliamentary session. So actually pre-Brexit and pre-COVID. When those two processes combined have led to an explosion of interest in statutory instruments that certainly wasn't true when we started studying them back in 2010. I'm going to demonstrate the tracker that we have developed out of our research to help people track and monitor the instruments that they're interested in. But first, we thought it would be useful to do a quick whistle-stop tour of the key scrutiny procedures, so that you have some sense of when we talk about the parliamentary scrutiny process, what are we talking about? Now, there's lots of variations on a theme, hence the complexity, but what I'm going to focus on today is the process for Section 8 instruments under the EU Withdrawal Act, which, as Abby referred to in her presentation, are going to have to do a lot of the heavy lifting in this process. So the government can lay an instrument subject to either the negative or the affirmative procedure in accordance with the provisions of Schedule 7 of the EU Withdrawal Act. And to think about the distinction, a negative instrument is subject to a passive form of scrutiny. They're made into law, but nothing happens with them in Parliament unless an MP or a peer raises concerns and objections. An affirmative instrument is a form of active scrutiny. They can't be made into law unless one or both houses has debated and approved them. Now, Section 8 orders, most of them are subject to a bespoke statutory procedure under the Act, whereby all negative instruments have to be sifted to see whether they should be upgraded from that passive form of scrutiny to that more active scrutiny, from negative to the affirmative procedure. And as a consequence, the government has to first publish the negative instruments as what are called proposals and send them to the designated sifting committee in each house. So for the House of Commons, that's the European Statutory Instrument Committee, known as ESIC. And for the House of Lords, that's the Secondary Legislation Scrutiny Committee, known as the SLSC. So the committees have got just 10 sitting days to take a look at these instruments, so not very long, and decide whether the procedure should be upgraded. The recommendations are binding. At the end of the sifting period, the government can lay the proposal however it likes, but if it rejects the upgrade, it has to explain why it's doing so. But to date, they have never rejected one. So they've always followed the committee's upgrade recommendation. So at this point, I'm going to share my screen, I hope, and show you flowcharts of some scrutiny procedures to explain the process. And I'm going to point to Ollie and ask him, can he see these? Excellent, thank you. Just to make sure we've got the right thing on screen. So basically, there are two key procedures: the negative and the affirmative. And it's not changing the page. Sorry about this, everyone. Don't know why this is. There we go. So two key procedures: the negative and the affirmative. So the first flowchart looks at the made negative procedure, which broadly takes 40 days. And a made negative is laid before Parliament after it's been made, but it can be annulled if a motion to do so, known as a prayer, is passed by either house within 40 days of it being laid. And recesses like we've got next week in Parliament don't count towards the 40 days. The clock stops ticking. Two committees certainly look at it. Other committees can choose to do so, but two committees will look at it. The Joint Committee on Statutory Instruments, which does legal and technical scrutiny, drawing the attention of the House about the virus, about defective drafting, and the Secondary Legislation Scrutiny Committee will look at politically or legally important issues, the merits of the instrument, is the policy objectives of the government likely to be met. They publish their reports, and if they have concerns about the instruments, they will draw them to the attention of each House. And if the committees pick up a problem, sometimes the government will respond and withdraw an instrument, but not always. And the government doesn't have to respond to the instrument. The critical question is, if you are an MP and want to object to an instrument, what can you do? Well, the only thing you can do is table a prayer motion through what's called the early day motion route. And the problem with that is no fixed time is allocated for debate. So whether or not the motion is debated is entirely in the hands of the government. They control the agenda on the floor of the House of Commons. And generally only time is granted to the leader of the opposition if he lays a prayer, and even that is not guaranteed. Prayer motions are also tabled in the Lords. They control their own agenda, so generally these are debated. But generally speaking, of course, the government will win the motion, win the vote. So it's a pretty inadequate scrutiny process. The higher level affirmative scrutiny procedure, these SIs are laid before Parliament as a draft. They can't be made into law by the Minister unless and until they've been debated and approved by both houses, or by the House of Commons, and in most cases also the House of Lords. The distinction is, if it's an instrument that deals with finance or tax procedures, it's likely to be House of Commons only. It takes around 4 to 6 weeks on average to complete all stages of the parliamentary process. The two committees, they scrutinise these instruments as well. And the distinction here is in the debating and approval process. So In the House of Commons, some of these affirmative instruments are debated in the chamber, but generally they're referred to a delegated legislation committee, or a DLC as they're known. Now, DLCs are not like select committees. They're temporary, they're not standing committees. They don't have secretariat supports. They don't have, members aren't briefed on the instruments that they're looking at. The members are appointed by the whips. They're not elected by the whole House. Sometimes the members will only get a few days' notice that they've been allocated to sit on a committee. And ultimately, the debates are frankly a bit pointless because they are held on a consideration motion that this committee has considered the instrument. They can debate it for up to 90 minutes, but most of the time it's pretty perfunctory, and the average time they spend on them is about 26 minutes. After they've considered it on that motion, the committee has confirmed that it's considered it. The approval motion then has to be laid in the House of Commons chamber and put formally to the House without debate on a separate day. And these rarely go to a division. They usually go through on the nod. In the House of Lords, broadly similar procedure, except they debate them not in what's called delegated legislation committees, but in what they call grand committee. And unlike in the Commons, they can amend the motion, the approval motion, to express concern or to effectively withhold the agreement of the House to the instrument. But that's a very, very rare thing for them to do. To put this all in context, the House of Commons has only rejected 11 instruments since 1950. The last time was in 1979. The House of Lords has only ever rejected 5 in that period, and the last one was in 2012. So all in all, it's pretty perfunctory, limited scrutiny. It's really inadequate given the importance of the legislation. If you think about some of the Brexit SIs running to, in some cases, 1,000 pages in length, debated in less than 90 minutes, it's not really technical legal scrutiny, certainly not, and often it's fairly perfunctory policy scrutiny as well, because MPs are not experts in the areas that they're being asked to look at with these instruments. So that's why organisations like the Hansard Society and lots of others now are pressing for reform of this process to improve it. So at this point, I'm just going to switch off the PowerPoint and switch to online so that I can show you the tracker, and hopefully this will now all make a little bit more sense, having gone through those broad procedures. Again, I'm going to look to Ollie to give me a thumbs up that he can see it. Excellent, thank you. So this is the Hansard Society Statutory Instrument Tracker that we've been developing since 2018. And what we've got here in front of us is essentially the homepage, the list of all statutory instruments that has been laid before Parliament since 2017 in chronological order. So you can see, the last one laid yesterday was a Brexit SI. We've also got highlighted some COVID-related statutory instruments. We're tracking the laying of SIs on a daily basis, and we track all the activity in both Houses of Parliament in relation to these SIs each sitting day, and then curate it through this tracker in a way that we hope makes the process more accessible for users. We list the new SIs laid in the last 7 days here in green, so you know which are the newer ones if you've not been and had a look at the tracker for a few days, and the later ones that are still live but are more than 7 days old, these are listed with an orange icon. Once they've completed their procedures, those icons go red and they sort of go into an archive. In addition to the instruments, we're also tracking consultations. Oh, we seem to have logged out. Sorry about this. So we're tracking consultations. So when the government's thinking about laying instruments and produces them in draft form officially for consultation, we put them into the tracker and again highlight if they're Brexit related. It's all judgments made on what the government says in its policy documentation. We don't make a judgment ourselves. We don't have the policy or legal expertise in-house to do that. And you can therefore track consultations in the way that you can with statutory instruments. The important thing here that distinguishes it from any other sort of parliamentary or other forms of databases listing instruments is that you can fine-tune your monitoring by saving consultations and instruments to your own personal dashboard. So you can monitor their progress and you can receive notifications here about what's happening to the instruments. And you can also, if you want, opt in to email notifications to get those whenever changes happen in Parliament to the instruments that you're interested in. And if we look at some individual instruments to dig down to the detail, if we look at this one that was laid yesterday, a Brexit instrument, official controls and phytosanitary conditions, this starts to give you a sense of what information about individual instruments is available. So it's a made negative, so it's that passive form of scrutiny. The Joint Committee on Statutory Instruments, the Secondary Legislation Scrutiny Committee will look at it, but there'll be no debate or vote unless MPs and peers request it, and if the government agrees to grant the time for it. Now, the tracker is designed to be a time saver for users in part, because it provides links to all the documentation, all the committee reports, all the debates around each instrument. So if you look here, you can see view the SI. If you click on that link, the hyperlink, it will take you to the legislation.gov.uk page with the regulation there. So it's easy to track the particular instrument. It gives the department that it's been laid by, the session. The purpose here is the headline purpose set out in the explanatory memorandum. Again, we don't draft this. It is simply taken from the government's explanatory memorandum. You get the key dates that may be of interest, when it was laid, the sifting process deadline, the date when it's made, the coming into force date, and so on. Again, hyperlinks to the powers under which the government has making the SI. So here the EU Withdrawal Act, but also this particular one, this recent one, relates to EU regulations. So you can click on the link and you get the link to that on legislation.gov.uk. And as Abby was highlighting in her presentation, you can see that there are some alerts on the government website about the updates that need to be made to some of this legislation. So that's the basics. If you've got an SI which is amending or revoking or in some way related to another instrument, and that's been indicated in either the text of the regulation or the explanatory memorandum, and if it's one that we have on our database, i.e. it was laid since 2017, it will also be highlighted here in the related section. So you can easily get to the instruments that you need to have a look at. So if you are interested in following this particular instrument, on the main list, you can go to the cross here and you can add it to your watch list, add it to your dashboard. I've already added mine, so it should appear here in your personalized dashboard. And there it is. So this is the watch list where you get all the notifications and the emails telling you about updates to the process, and you also get calendars here and also a bigger one here, an events calendar for the upcoming changes to the instrument that are expected as part of the parliamentary process. So for looking at EU withdrawal agreement instruments that are subject to sifting, subject to this Section 8 sifting process, if we look at one I saved here earlier, the food and drink regulations, which was laid on the 11th of January, this is still live. It hasn't completed its process. As you can see, it's got a custom alert here. The instrument has been recommended for upgrade, negative to the affirmative. If we click on the SI here, it hasn't got a number because it hasn't yet been made. And it doesn't take you to legislation.gov.uk, it takes you to the main government website because this is still a proposed instrument. They have not laid it formally. It's simply been published for the purposes of sifting. And what we're waiting for is whether it is going to be upgraded or not. And then it will go through one of the routes of either negative or affirmative scrutiny, depending upon what the government decides. When you get to this page, you scroll down and the proposed instrument is there along with the explanatory memorandum. If the government, when and if the government upgrades that, lays it formally before Parliament, that hyperlink will change and it will lead to the main instrument. What you can see here then is, because it's been sifted, you get a parliamentary activity bar because there's been some activity in Parliament in regards to it. So it's been considered by the Designated Commons Committee and the Designated Lords Committee. These bars only highlight green if some activity has been scheduled or completed. And down here, you get transcripts and reports. So the Designated Lords Committee, the SLSC, has produced a report on the instrument. So that will be what they wanted to report on, recommending the upgrade. So if you link to that, you can see the report about the instrument. So just one more, just to have a quick look at, go back to my dashboard, and we'll have a look at an instrument subject to the affirmative procedure, which is the Communications Act regulations laid last summer. So I've chosen this one simply because it's completed all its scrutiny stages. It's been made by ministers, and thus the full range of information is displayed. Firstly, you can view the SI here. It's got a number because it's been made, and that will take you to the instrument on legislation.gov.uk. You get all the key dates again. But the key difference for affirmative SIs is that you get an extended parliamentary activity bar here. Now, again, some of these, if it was in process, if it was a live instrument, some of these would be greyed out. The activity wouldn't yet have been confirmed. And you can see we've got some custom alerts here because the instrument was upgraded from the negative to the affirmative procedure. The sifting committees considered the instrument in deciding whether to upgrade it. And you can see the reports here, both from the SLSC and ESIC. Click on those and those will take you to the relevant reports. And because this is an affirmative, it has to be debated in the Commons and Lords, and it has to be voted upon. So what you've got here is, after the Commons debate on the 20th of October, we then put the link into the House of Commons Hansard transcript. So you click on that, and that takes you to the debate on the regulations that took place in a committee, gives you the committee members who were part of it, and you can see the debate in full. And we do the same for the House of Lords. For different types of orders, you might get some other links. So for remedial orders, for example, you'd get a link here to the Joint Committee on Statutory Instruments and the Human Rights, Joint Committee on Human Rights that will consider it, and possibly even a departmental select committee. So it tries to curate all the information in an accessible way. It's very much what I've given you today is very much a whistle-stop tour. There's an awful lot more functionality in there if you're a heavy user of SIs, but I hope that's a useful introduction to it. So back to you, Adrian.
Thank you. We're going to go straight over to Ollie because we're running a little bit late, but we can go to 104, 105 if necessary. Thanks very much.
Great. Thank you so much, Ruth. I love the term heavy user of SIs. That's a level of geeky that I am here for. Amy, if it's all right for you to share my screen, I will take this very quickly and will not eat up too much of your afternoon, I promise. So that's me. Next slide, please. This is a slide from yesterday, so I'm sure you all remember it really well, which is setting out what EU-derived legislation is and what the test is. And I'm going to give you a worked example of how that happens in relation to a piece of primary legislation, namely the Equality Act. So just fix that in your head right now, and we'll move on to the next slide in about 10 seconds. Remember the bits in red in particular. That was a bit less than 10 seconds, but hopefully that worked. Okay, so what is the Equality Act? I know most of you will know it here, but many won't if you're not equality law practitioners. It essentially consolidated a series of other pieces of anti-discrimination legislation, including legislation that went way back to the 70s. So if you remember the bits that I highlighted in red on the previous slide, operating for a purpose relating otherwise to EU EEA, that means that retained EU-derived legislation is exceptionally broad in scope. It is hard to even imagine parts of the Equality Act that are not operating for a purpose that relates to the EU. Even if it wasn't derived from a directive, it could derive from case law, such as PNS against Cornwall around gender reassignment. So it's exceptionally broad. Potentially the public sector equality duty isn't so squarely EU related. But let's, for our purposes, assume that the Equality Act as a whole is a retained domestic EU-derived law. And what happens to that? Well, there's an interpretive obligation in relation to EU case law and general principles. So as far as, so in relation to case law pre-IP completion day, so end of December 2020, to the extent that the domestic law is not modified and it's relevant, the courts are going to look at it to inform construction. Post-IP completion day, they may have regard, a much looser duty for case law that's happening now and the case law and general principles as they emerge. Pre-IP completion day, very important for construction. Post-IP completion day, less important, a due regard duty. Now, supremacy is quite a tricky one. Section 5 of EUA was heavily criticised during the drafting process for being utterly opaque. And the House of Lords Constitution Committee came to the conclusion that actually, and this is what the Solicitor General argued as well, is that actually it doesn't apply to acts of parliament, etc., that become retained EU law, because it would give them a special status that they never had when we were in the EU. They didn't suddenly magically become transformed. But that's going to be a point that's going to be explored in litigation. If it is supreme, that's quite extraordinary, because the Equality Act could, in theory, if it's supreme over other primary legislation, does that mean you can disapply primary legislation that is not retained EU law, which has puts a fetter on the Equality Act? For the example I'm thinking of is the Children and Families Act 2014, which provides that there's no right of appeal to the Special Educational Needs Tribunal in relation to Equality Act claims for children. That's a fetter on an Equality Act right. Can the Equality Act now be used to argue that's unlawful? It's a live question. It's really interesting. The problem with flagging that the Equality Act might be retained EU law is it then opens it up to being attacked via Section 8 EUA and amended on the sly. So we're going to have to be really careful about monitoring statutory instruments, using the statutory instrument tracker to make sure that there are not sly changes to important pieces of primary legislation that come within the purview of EUA when we might not have even identified them as being retained EU law. Next slide, please. So I'm briefly going to give you an example of a statutory instrument that has been challenged by means of judicial review and unsuccessfully, and I put that in inverted commas, challenged, because the permission decision was, it was refused permission by Justice Leven a couple of years ago, or just under 18 months ago, something like that. But it was quite a success for the client, Earth and the Marine Conservation Society. And quite interesting about the court's approach to Brexit-related statutory instruments and the Section 8 EUA power. So, in short, this statutory instrument amended a piece of EU-derived domestic legislation, the Habitats Regulations, which were implemented the Habitats Regulations. And you don't need to know a huge amount about environmental law to know that this concerned the Natura 2000 network, i.e. a network of areas that were special conservation areas. Now, the 2019 regulations made under Section 8 EUA did quite a lot of things. One thing that they did do was insert the provision that I've highlighted, and where necessary to adapt. And Client Earth, who were challenging this, were like, wait, where did that come from? That's not a deficiency in retained EU law. This wasn't a technical amendment. This is inserting a new power for the government to potentially undercut preservation of natural environment. And they were very concerned about it and sought judicial review. And ultimately, they were refused permission and the regulations were found to be lawful. But what they did say was that in refusing permission, the High Court said, if exercising this regulation, the government went out with the powers as set out in the directive, then they would find that act to be unlawful. So you can then see the directive, because it's been interpreted in EU case law, it remains an interpretive aid going forwards and will constrain the exercise of powers under this regulation. So whilst it was technically permission was refused, we've got quite a lot of insight into how the courts might approach challenges to EUA Section 8 and the important role going forward of, and I've lost my screen, Amy, is it possible to share again, please? And the important role going forward of retained EU case law and the case law of the EU that progresses because it has a may regard duty. If I can't, given an interest of time, I think we've lost Amy, but I'm going to just wing it without my final slide, which was setting out some hints and tips for how to challenge these statutory instruments. And they're quite straightforward points, and you'll get them on the slides when they get sent around. The main point that you're going to be arguing is ultra vires, that it is out with the power conferred by the legislation that ministers made the regulations. So ultra vires isn't that complicated. You need to look at the piece of primary legislation, the delegated power, look at the terms of it, then look at the legislation that's being amended. That's the basic approach to it. There are some tricks and licks and there are some principles that you need to think about, but that is the essential principle. That is the heart of it. It's quite a straightforward exercise. Then what other grounds of argument could you have? Well, you could have a human rights ground of challenge. For example, you might argue that it's a breach of the right to family life. You might reach right to property rights, etc. Amy, if you could go to the penultimate slide, please, which says challenging SIs, that would be brilliant. Cheers, perfect. So human rights. So proportionality is likely to be key to this. And this really links in with what Ruth was saying earlier. So the courts, the Supreme Court in Matheson, for example, gave quite a lot of consideration to the fact that very little had been said about the statutory instrument in Parliament, that there had been very little scrutiny was relevant when they were deciding the lawfulness of a statutory instrument. Now, that is highly relevant to the flawed scrutiny processes that Brexit statutory instruments have, because they're going through on the fly quite often never debated in Parliament. Then is that adequate scrutiny? Is the complete failure of the scrutiny process going to help you with your proportionality arguments that you make in a judicial review? I also just wanted to flag the case of Javed, which makes clear that Article 9 Bill of Rights about impugning parliamentary speech, the idea that courts won't look at what Parliament says in too much detail, doesn't apply in relation to statutory instruments. So don't be too worried about that. Then very briefly, and ironically on timing, given we're overrunning, I'm going to talk about prematurity and ripeness for about 30 seconds. When can you challenge an SI, and when does your limitation period run from for the purposes of judicial review? And that is an exceptionally hard question. And to be slightly cheeky, instruct us if you want to know the answer. But it depends, is the lawyer's answer. The general principle with challenging any act or decision by the executive is when it becomes a sufficiently clear decision that the decision has crystallized that it can be challenged. So that could actually be at a very early stage in draft of the regulations. Formally, the decision is when it is made, when it is signed by a minister. So that is the latest date that it would run from. But it could run from before that, and it will be context sensitive, depending on how crystallized it's become. Now, in addition to the absolutely fantastic SI tracker, which I highly commend, I really suggest that you look at the research that has been produced by Public Law Project, who are my former colleagues, the work of Alexandra Sinclair and Dr. Joe Tomlinson around statutory instruments. They've just published a really excellent report going through all of their research monitoring Brexit-related statutory instruments. And it identifies key themes and problems with Brexit-related SIs. And that will give you some insight about the kind of problems that are emerging in Brexit-related secondary legislation, and will help you identify problems with SIs that you just think feel wrong or unfair, but you can't quite put your finger on what the unlawfulness is with them. And on that note, I'm going to end. I'm conscious that I've taken up 8 minutes of your time, but if you have any questions, I'm very happy to answer them via email, and I'll put my email address in the chat.
Thanks, Ollie, very much. And thank you, everybody, for bearing with us as we've run slightly over time. That concludes the second part of our seminar. We hope that, like us, you are enthusiastic about challenging points based around retained EU law and looking at statutory instruments made under it in the fields of work that you do. And I'm sure that we'll all have plenty of time for further discussion. We'll probably have to run sessions later in the year and beyond on this topic, because it's an evolving topic and we're all getting to grips with it. So it's a shared endeavour. Thank you all very much for joining us over these last 2 days, and good luck in this new field of administrative and public law. Thank you very much.